consult with an attorney employed and retained by a public body in order to preserve the attorney-client privilege between the attorney and the public body, which privilege is hereby acknowledged. We have a motion to recess.
Oh, before you do that, this was on the agenda in case it was needed.
Oh.
So if it's not needed, which I don't think it is, unless there's something I don't know about.
No.
We don't need to do it.
There's no motion.
All right, business from council.
Yes, I have something. Nobody else does. And it goes to the ethics code and the council policing itself. November 6, 2009, the Northwest Observer, page 2, in an article entitled "Council Releases Closed Session Minutes," the editor or a reporter wrote, David Lawrence, a professor with the UNC School of Government, said closed session should not include discussions of committee appointments. The open meetings laws permit a closed session to discuss appointment of people to employment positions with a local government. If the appointment is not to an employment position, however, but to a board or commission, another public body, the statute specifically states that any such discussion of such an appointment must come in open session. In light of the expert's opinion, and in light of documented Public Record Act's request from a citizen over 4 years ago for unsealing and disclosure of all closed minutes, I feel this council has an ethical and legal obligation to police itself and ask the town attorney to look into the chain of custody, storage, secretion, and discovery of the 13 sets of closed session minutes unsealed at last month's and tonight's meeting, but never released to the requester per the Public Record Act's request. I so make that motion.
I'll second it. Can you hear me?
I heard you.
Okay, we have a motion for something and we have a second.
So what they're asking is to have the records removed back from out of off-site storage.
I'm asking for the attorney to do the investigation regarding the Public Record Act's request not being honored timely per the law.
Okay. I reckon my first thought is what information do we have that in storage or wherever that would give the attorney this information?
That's why the attorney conducts an investigation.
Okay.
Doesn't necessarily have to start with documents, it starts with people.
Okay. I reckon my hesitation is I don't exactly know, I can't understand what the attorney is looking for. I don't know what the motion is asking the attorney to
The
do.
motion is to ask the attorney to find out where the records were for 4.5 years when the Public Request Act wasn't honored, and why the Public Request Act was not honored timely by the custodian of records, who was Ms. Diane Laughlin at the time, and who is going to be sitting on this council next month.
Okay.
And if this council is serious about ethics and policing itself, then it'll show tonight.
Okay, I'm just trying to figure out what, okay, we've got a motion and we've got a second, and we're open for discussion. What's the rest of the council's thoughts as far as investigation as to the opening and closing or maintaining the closing of records? I don't see a problem with that, having the attorney to look in. If that's the way we wish for it to go through the attorney, I
Mr. Hill about it today, Mr. Select, he suggested doing it,
Uh-huh. Okay.
because it would require extra time.
Yeah, I see what you're saying, yeah. Would it,
They didn't suggest it to us, to the council.
I had a big conversation with him. And Blair and he talked today.
The conversation did take place.
okay. Well, the first thought is let's go. I can't think of any other reason not to. Because we want to be straightforward and we want to be open with all of our stuff that we can be open with, et cetera. And I can't think of anything else to do but the first thought.
I agree, and I think that the issue needs to be addressed and then be over and done with and move on.
I wasn't here at that time, so I don't know what you're talking about, what records you're discussing about.
Summerfield minutes. The motion was made 4.5 years ago by a citizen to have these records disclosed. They were never released. It's the investigation. That's a violation of the law, by the way, not.
I know what the law is, Mr. Strickland, and I know that it was operating under the advice of the attorney at that time. Not a paralegal assistant either. It was a bona fide licensed attorney by the North Carolina board.
I think part of the motion is that the attorney investigate why the public records request wasn't honored. That has nothing to do with the attorney.
It's okay to send a record.
Let's don't get involved. Okay, have a motion and a second. Discussion, do we want to, further discuss it, or do we want to vote on it?
If nobody has anything else to say, I'd like to call for a vote.
You either give the appearance of lip service to
Why don't
ethics.
you just go away first?
I'm not going to. You either give the appearance of openness and honesty, or you don't.
They've been open.
Yeah.
They were not opened when they were supposed to be, Mr. Williams, and that's what I'm asking the attorney to investigate. That's what the second to the motion is.
How much will it cost to have? Yeah. I think that's very important, we're spending our money.
All right. Okay. Do we need, do we more discussion before we call the vote?
Yes, we just discussed an ethics code whereby we were talking about how it was going to be enforced. And the suggestion by Ms. Flowers was if one person raised the issue, then the attorney should address it. Now, two people have raised the issues, and you all don't want to address it.
I'm just waiting for discussion.
We'll discuss it.